Meeting of the Marquette Township Zoning Board of Appeals to order at 5:31 p.m. on Thursday, January 25th. Because of our chairperson vacating his seat and no longer being on the Zoning Board of Appeals, and the vice chair being a board member from last year, he's not able to serve, so I'll just get us to the point where we can get to the election of officers for 2024. So with that, we'll do roll call, so please state each member your name and address for the record.
Name as William Prescott, 1203 Woodridge.
Jim Johnson, White Oak Drive.
John Marks, 5. Part-time.
Brent Graves, 115 Hidden Springs Drive.
Pete LaRue, 2082 Huron Street.
Jason McCarthy, Planning and Zoning Administrator.
Roger Zappa, Township Attorney.
And we also have Mr. Becker, Jim Becker, who is our alternate, and will be participating tonight eventually. So with that, as it is the first meeting of the 2024 season, if you will, we will entertain motions for election of officers. So we're going to be looking for a chairperson, a vice chairperson, and a secretary. And anyway, open for motions for the position of chairperson.
Well, I think the public has, just a note, both I and cannot serve as chair.
Yeah, Mr. Marks is on the Township Board of Trustees, and Mr. Johnson is the chairperson of the Planning Commission. Although both required by state statute to participate on the Zoning Board of Appeals, neither one can hold a position of office on the ZBA.
I'm willing to do it, and I don't see anybody jumping up, but I don't know how we handle that in a motion.
I'd like to nominate Pete LaRue for the chair.
I'll second that.
Okay.
Motion and a second for Pete LaRue to be the chairperson. Any further discussion on that?
You sure there's nobody else who'd like to do that? Just because of lack of experience in my first meeting, so
We'll guide you through, Pete,
that's what I'm afraid of.
if you are successful. Any additional comments, questions? All those in favor say aye.
Aye.
All those opposed say nay. Pete, congratulations, you're the chairperson, and I will hand the meeting over to you. And the next up would be the appointment of the vice chairperson.
Okay. We have a motion for the vice chair.
I'll nominate John Marks for vice chair.
It would be preferable for John Marks not to be either chair or vice chair by virtue of his statutory membership as a township board member.
Thank you.
And the rationale on that is because while the statute does not prohibit a board member from being a vice chair, the very nature of a vice chair is in the absence of a chairperson, the vice chair will become and serve as the chairperson.
So another name would be appropriate.
Correct.
Do I hear another motion? Do we hear any volunteers? Bill? Bill, would you serve? Your job? Would you serve as vice chair? I guess so.
Is that a motion?
Motion has been made and supported to have Bill be the vice chair.
Who's the support?
I'll support.
I support.
So just to be clear, John, you nominated Mr. Truscott. Okay.
All in favor, say aye.
Aye.
Opposed, same. Okay. Next would be the secretary. Is that right? Okay, we need a motion for someone to be the secretary. Do we hear any motions for secretary?
Who's left? We can't do that either.
It can't be a chair or a co-chair. It does.
The only prohibition is you can't be a chair.
Okay. I'll nominate John Marks for secretary.
I'll second that. Are you willing to do that, John?
Yes.
Motion for John Marks to do the secretary. All in favor, say aye.
Aye.
Opposed, the same.
Good thing we only do that once a year.
Thank you.
Okay. Pete, on to number 3.
Minutes,
No,
approval agenda. Make a motion to approve.
Make a motion to approve the agenda as presented.
All in favor, say aye.
no, second.
Second, excuse me.
Second.
Jim Johnson.
Seconded by Jim Johnson. All in favor, say aye.
Aye.
Opposed, the same.
Okay, so there's no minutes
No
at this
minutes.
time, so we can skip that.
Public comment.
This would be other than the agenda items, so as this is a public hearing, you'll have an opportunity to speak on the agenda item being heard tonight. So this would be anything under the sun other than the agenda item.
Seen anyone?
Usually we go first call, second call, third call, done.
Yep. Just like playing bingo. Anyone bingos? Okay. First call. Any public comment on the ones?
We've got one.
Where? Oh. Any other public comment? Any other public comment? Hearing none? Okay. Then we're down to new business. ZBA appeal request. Who handles that?
I'll read it for you.
Okay.
Agenda item 6A tonight is ZBA appeal request number 012524-1 to consider an appeal of a planning commission decision made on Longyear Realty Corporation's Forestville Community Final Plan Unit Development, or PUD, Phase 1A, which was made at their regular meeting on October 24th, 2023. Project location is in Section 8, T48 North, R25 West. The subject parcel tax ID number is 52-08-008-004-00. The subject property is located within the zone scenic residential district. The applicant is Mr. David Pesala of 135 Forestville Road, Marquette, Michigan 49855. So what I want the ZBA members to pay attention to for this evening is page 4 of your bylaws, which is handed out to you. And it indicates what and how a public hearing is conducted by the Zoning Board of Appeals. So under item E, public hearings, all public hearings held by the Zoning Board of Appeals must be held as part of a regular or special meeting of the Zoning Board of Appeals, which this is. The following rules of procedure shall apply to public hearings held by the ZBA. 1, the chairperson opens the public hearing and announces the subject. Pete,
Yes.
we read off the agenda items, so I think that would qualify. But we have to open, you have to open the public hearing and state a specific time, which is 5:40 PM right now.
Okay, public hearing is open.
And at this time, because Jim Johnson participated in the original planning commission decision, he will step down. Mr. Becker, our alternate ZBA member, will become a member of the ZBA for the remainder of the meeting. Or, I'm sorry, until the public hearing is closed.
Where'd you find it?
Sure.
That's the one we got.
And it's on page 4.
At this point, now that the public hearing is open, the Zoning Board of Appeals regularly hears variances and operates like a finely oiled machine, essentially. This is something a little different. You have before you tonight an appeal, which is a review of the Planning Commission's decision that has been presented. Now, normally your township attorney is not here for ZBA hearings, but I'm here to provide you with a little bit more information. This involves an application of law more than a factual determination that occurs in variances and other matters that the ZBA hears, for example, on a regular basis. Generally, the Zoning Board of Appeals is a creature of statute. It's statutorily created by the state legislature. The Zoning Board of Appeals only has authority to hear certain matters, has jurisdiction to hear certain matters. If there is no authority in either the state legislation, the Zoning Enabling Act in this case, or the Township Zoning Ordinance, then the Township Zoning Board of Appeals has no authority to hear or decide those types of appeals or issues. Section 603, subsection 1 of the Zoning Enabling Act, which is MCL 125.3603, subsection 1, indicates that planned unit developments, or PUDs, decisions or appeals of those may only be appealed to the Zoning Board of Appeals if the Township Zoning Ordinance so provides or expressly authorizes that type of an appeal. The Michigan Township Association, whom you're probably all familiar with, has made observations and comments in its publications that it's a rare zoning ordinance that authorizes appeals from a PUD decision to the Zoning Board of Appeals. Consistent with that observation, turning to the township's zoning ordinance, we turn to section 1306, subsection B, and subsection 4 thereof, it indicates no part of this PUD process of the approved site plans may be appealed to the Zoning Board of Appeals. And that's after it lists a long group of criteria that the Planning Commission is required to consider when it initially approves or denies a PUD decision. So in this case, the zoning ordinance expressly indicates that the Zoning Board of Appeals has no authority to hear an appeal from a PUD decision. Now, that raises the next question of why are we then here? Why are we having a public hearing? Well, again, the whole process is very much legislative. It comes from our state legislature. And the Section 3604, subsection 5 of the Zoning Enabling Act indicates that if the Zoning Board of Appeals receives a written request seeking an interpretation of the zoning ordinance or an appeal of an administrative decision, the Zoning Board of Appeals shall conduct a public hearing. Shall being mandatory, it's not an optional thing. An appeal was received. Consequently, that invokes the requirement to convene a public hearing. That's not necessarily the most efficient way, in my opinion, to handle these matters, but that is what the legislature has prescribed as the process. So here we are at the public hearing. Tonight, what this Zoning Board of Appeals has to determine is whether there is some way to hear this appeal, to hear the merits of the appeal. And by the merits, I mean the issues of did the planning commission give enough weight to this criteria or to these other criteria. That would be addressing the merits. In this situation, both the state statute and the zoning ordinance are reasonably clear that it would be an overreaching of the zoning board of appeals to get that far or to address those issues. And that's pretty much the conclusion that I've reached as your township attorney. There's also a secondary issue. Even if the ZBA possessed the authority, or the jurisdiction is the legal terminology, to actually reach or address the merits of this appeal, the actual issues and what was considered or what was not considered by the Planning Commission, there's a timeliness issue of the appeal. Section 24.07, subsection A of the zoning ordinance requires the zoning board of appeals, a zoning board of appeals appeal to be filed within 30 days from the date of the contested decision, and that's a direct quote. This decision that is being appealed was issued by the Planning Commission on October 25 of 2023. By my calculation, 30 days therefrom would be November 24, 2023. The appeal was not filed with Marquette Township or received by Marquette Township in that timeline. So that would form an additional basis for the essentially legal findings, if you will, rather than factual findings of the Zoning Board of Appeals this evening. The procedure also allows, as in any public hearing, both written comment, which may be submitted up to the commencement of the appeal, of the public hearing, and oral public comment. And it's my recommendation that you proceed in that fashion, to take both the written, if any, and oral, if any, public comment that is offered. And that would be on whatever subject pertaining to this that anyone wishes to make. However, before we reach that, because the public probably hasn't participated in a lot of these, nor has it been a while at least since the ZBA has done one of these, normally the first thing that would occur is the appellant or appellant's attorney would be afforded the privilege of speaking to the ZBA and presenting the appellant's position. So that would come first. Then would come the written receipt of written commentary from the public, and then would come the oral public commentary from the public. That's in essence the general order of things, so people know what to expect and when to expect it. Then finally, because everything comes in an order, in order to be fair to everyone, the party whose development it is, of course, is intimately involved in whatever happens in this case, so they would be offered an opportunity to make comment if they wish. And then Mr. Mead, on behalf of the appellant, would be offered a final opportunity to again speak if desired. There's no requirement that anybody participate in that commentary. But that's generally the order that the public hearing should occur in. When there is no one else who wishes to speak, the public hearing would then be concluded and the time announced. And then at that point, the Zoning Board of Appeals would begin to deliberate and determine what, if any, action it wishes to take. That would be after the public hearing itself is closed, but still part of the public meeting. And that would also, just for clarification, thanks to Mr. Becker, who is appointed specifically for purposes like this, because state law says in certain circumstances, certain members can't participate or vote. But Mr. Becker sometimes isn't involved as an alternate, but the Marquette Township Board is required to appoint at least one alternate, and he's graciously serving here tonight in that capacity, which means that Jim Johnson, who is the planning commissioner liaison to this zoning board of appeals, will not be participating in either the public hearing or in any deliberations relating to a decision in this matter. If there were to be other items on the agenda, which I'm not seeing any, but if there were, then at the conclusion of a vote on the decision at hand this evening, then your planning commission liaison would be permitted to return to the table and participate in discussions. That is generally the procedure and the protocol. I'm sorry for being a little long-winded, but I know this is new to some people. I wanted to lay that out to make you help you understand what we're doing and why we're doing it this evening.
Thank you.
So under your bylaws on E, number 3 would be the applicant or the appellant's opportunity to present their request for the appeal this evening.
Good evening. My name is Daniel Mead. I represent Mr. Pisola in this matter. The brief that I submitted, I hope you read. I hope you understood what it said. Attorneys draft things kind of knowing where other attorneys are going to go. So if you paid attention to my brief, I already addressed Mr. Zappa's concerns. And already basically attacked and put to bed those issues. Underneath MCL 125-3604, which was correctly cited, but what Mr. Zappa left out of his analysis is section 2407, the appeals section within the Marquette Township. And we are going to rely on, at the next level, hopefully you don't let it get to that point, but, or other contested actions. Your ordinance does provide for it. So underneath MCL 125-3604, it indicates PUDs can be contested if provided for underneath the zoning ordinance. 2407 specifically says other contested actions. If you didn't want that as the legislative body, you should remove that then. That allows me to loosely connect the other contested action. I already briefed it, I already anticipated the argument, good to go. The timeliness requirement, again, Mr. Zappa should have read and should have interpreted and pointed out to you regarding the timeliness is that all final PUDs pursuant to 1306 are required to be followed underneath the preliminary procedure. And what does the preliminary procedure say? 1305B3 says that you're required to basically write like they did in the preliminary stage, that I agree as Longyear to follow your conditions. And the Planning Commission had 3. There has never been a letter from Longyear to trigger my 30-day requirement. Therefore, my appeal is timely. What can happen as a result of tonight? We can appeal the decision to the circuit court, or I can tell you most likely what's going to happen is what's referred to as an original action. My client's property has been taken. The Planning Commission allowed 100 units to be built, which could then be said that the Planning Commission allowed a private taking, inverse condemnation, and the Constitution requires that you have to pay just compensation when you take somebody's property. We know that because the road is going to have to be fixed along Wright Street, and depending on which one you refer to them as, HD or Forestville. My client owns on both sides. So that's a private entity, Longyear, that doesn't have the ability to condemn. So if the road commission then comes back and says we have an unsafe situation The only reason that there's an unsafe situation is because of the vote that currently happened in October of 2023, which was done by the Planning Commission. So I hope that you paid attention to the brief. I hope you don't get sidelined by the arguments that I already briefed that I knew were gonna be raised. It's timely because Longyear has to submit a letter agreeing to follow. That's my trigger. 1305B. Secondly, loosely, although squarely, I have the ability to appeal pursuant to 2407. It says that any contested matter. So I hope you don't get sidelined. This is a pretty serious issue. Taking actions are serious if just compensation and the Constitution aren't followed for paying reasonable compensation for the individual that's going to have land taken. We know from the traffic survey that land is going to have to be taken from Mr. Pasola in order to fix Wright Street. They even drew you a diagram of it in the traffic study. There was absolutely no consideration given to that traffic study. There was no consideration given to the Marquette County's Road Commission's letter in April that basically said it cannot support the PUD. It said it. Item 2. April 26, 2023. Road Commission told the Planning Commission it could not accept that amount of traffic. One of the requirements for the PUD is can the roads support the traffic? So unless you have any questions of me, those are the only 3 points that I want to make.
I have a question.
Sure.
Were you provided the attorney for the board, for the planning commission, for the township? Were you provided his comments?
No, so we're never provided that. Those are your comments. He's your attorney-client privilege. That's what you get. He indicated the two that he was going to make like an legal issue today. I've addressed those. I already knew they were coming. That's why I addressed them in my brief before he even spoke to you.
Right. So we got a lot of information from the township attorney, but you've had not been previously informed of that or had time to investigate or address those.
Correct. So the two issues that he addressed.
Today, that he brought up
Correct.
today.
I already
verbally.
knew he was going to address those in my brief. My brief became before any of his comments to you.
Okay.
And so I'm pointing those out in my brief. I can literally point you to them and page number.
And then we also got something from Varnum, another attorney who represents Longyear. Have you ever
I'm
seen that?
sure they want to basically.
Have you ever seen that or had an
No.
opportunity to respond to it?
No.
Okay.
So, and that would be, so that is not protected by attorney-client privilege. Should that have been made part of the packet, an argument can be made regarding that. I appreciate that.
And maybe you guys know, have we been provided this traffic study and the letter from the
There's two
Marquette
letters.
County
There's
Road Commission?
one in April, one in October. The one in October, which was relied upon in the Planning Commission's approval, said follow the October of 2023 letter, which basically references the April letter, just so you're aware.
But I haven't seen those.
Yeah, they're really specific. They basically said the planned unit development cannot move forward because the road cannot support the amount of traffic. And then the October letter said no more than 100, and then it has to be fixed. That's why I know there's inverse condemnation. So a private entity like Longyear can't go take Mr. Pasola's land. So then is that going to be inverse, meaning we now have increased volume of traffic and the road commission has to step in because they are an entity that has the ability to take land. And that's the inverse nature of it, is you're supposed to do all those things first before you make any decisions. And that's the other thing
That
too
would make
is.
sense,
Yes.
that,
How are we going to fix this problem before it becomes a problem? But the traffic study
but
gives,
instead the can was kicked down the road and somehow somebody in the future is gonna know more in order to make this decision than we knew when the decision was made. I don't know why this couldn't be figured out ahead of time.
so there's
Does anybody
two,
have an answer for that?
there's two fixes that are provided in the traffic study. Now, will those change in the future? I don't know. So there's the boulevard option, which seems to be the number one option. And then there is a move the entrance off of Forestville Road down. And I want to say they say, I don't know off the top of my head if they say north or south on that one, but those are the two options. Will those change in the future? I don't know.
Yeah, I spent a lot of time with the planned unit development regulations and the zoning ordinances, getting ready for this meeting. And yeah, it doesn't even seem close to meet the qualifications for a planned unit development. I know that's not our issue here, but I was amazed at the decision to approve this in the first place without knowing how you're gonna deal with the situation that this is gonna create. And just think that somehow somebody in the future is gonna come up with a brilliant way to deal with it, but we're not gonna deal with it. So, I would like to see in writing a response from Dr. Pessela's attorney in response to all the other stuff we've gotten from attorneys. Because I'm not an attorney, and I don't know how to interpret, Mr. Zappa's comments. I don't know how to interpret Mr.
Mead.
No,
Mead.
not you,
Okay.
the one from Longyear, whatever his name, the Longyear lawyer. We got a long statement from him just yesterday afternoon. I read it last night, and I'd like to. It seems that due process would indicate that we give Dr. Pessela and his representation an opportunity to respond to what we've been told.
Sure, I would appreciate that, honestly. Any other questions for me?
Thank you.
Thank you.
Any other?
Well, in response, the statutes and ordinances follow the same general principles for interpretation. A specific statutory provision supersedes or overrides a general statutory provision. The provision that Mr. Mead referenced in Section 24, Article 24 of the zoning ordinance is a general provision that says the Zoning Board of Appeals can hear contested decisions. That comes directly from the Zoning Enabling Act, but keep in mind, as I've already indicated, the Zoning Enabling Act says a ZBA can only hear and decide issues involving PUDs if your zoning ordinance expressly grants that authority. Your zoning ordinance does not expressly grant that authority, and in fact prohibits it in Section 1306B4 that I've quoted for you already. So that's your preliminary issue. Regardless of what the merits of the underlying claim might be, should the Planning Commission have done X or should the Planning Commission done Y? If the Zoning Board of Appeals reaches those issues, it's my position that they are doing so unlawfully, that they're exceeding the scope of their legal authority.
And what would that mean?
Your decision is void. And then it would probably place the township in a position of having to appeal.
And that would then be sent to whom to decide?
Well, I guess we'll cross that bridge when we get to it, but presumably circuit court.
Pete?
John?
Are there any other comments made from the audience?
Well, we're not quite there yet, but
I finished with,
the other comment that I had was that keep in mind, and I think you're all aware, that what was approved here was not 100 units. It was 16 units in a Phase 1A of the development. And that even is beyond the scope of what's being discussed here. But that's what was approved. That's what the merits are talking about in the appeal, in the underlying appeal.
Yeah.
yes.
I'd be curious to hear your attorney address Mr. Zappa's point again about the legitimacy of, or even hearing this.
Again, I did. So my opinion.
Well, I'd like to hear it
isn't
again.
gonna- Yeah, my opinion isn't going to change because Mr. Zappa.
I'm not suggesting it
Up to the
would.
mic, please.
So it's basically the yin and yang of attorneys. He's not going to concede, I'm not going to concede, so that's what we have judges for. So ultimately, you can act as the judge and you can agree with me on my interpretation of the law, or you can agree with Mr. Zappa. But ultimately, there is no harm that comes of that. That's why we have appeal processes for judges and courts to basically oversee the decision. I have given you, even before I knew he was going to make his argument, a timeliness argument, which he hasn't addressed, just so you're paying keen attention. And number two, regarding the ability is so the statute, MCL 125-3604, says that it must address. It doesn't say that I have to specifically address. That's what he's trying to buffalo you on. So the statute or the ordinance underneath 2407 says any contested matter. I fall underneath. It just has to fall underneath the zoning ordinance. That's what the statute under MCL 25-3604 says. It must be addressed. It doesn't say specifically address. PUD can be appealed. There's no requirement for that. So underneath the statutory sequence that Mr. Zappa is talking about is that I have to meet that statutory requirement. There must be something that's indicated underneath your zoning ordinance. I have pointed it out to you. Now, we're at the point in time, you agree with Mr. Zappa or you agree with me. And whatever the decision may be, that's the decision, and then we have things that, when I said earlier, we're going to continue to march on this. Yes.
Thank you.
Several times, Mr. Zappa said that the zoning board of appeals is not allowed to consider an appeal of a planned unit development unless the zoning ordinance expressly says that we can. Is that word expressly in there?
No.
Here, let me read it for you expressly what the statute says, what the state legislature says. MCL 125.3603 subsection 1, and the same thing applies, by the way, for conditional or special use permit appeals, which we're not dealing with here, but it starts out, for special land use and planned unit development decisions, an appeal must be an appeal may be taken to the zoning board of appeals only if provided for in the zoning ordinance. And that's where the Michigan Township Association has basically expressed the opinion that it's a very rare zoning ordinance that does provide for appeals of PUD decisions. And in order to provide for PUD decisions, the only way to do that is to say the ZBA has authority to hear PUD appeals. Your ordinance does not say that. And that's what I was referring to when I said the specific overrides the general in rules of interpretation of whether we're talking ordinances or statutes. You have a specific provision that says you can't, there is no appeal of a PUD decision to the ZBA. That is in your ordinance, and that we're going, over and over the same thing here again, but that is in your ordinance.
Again,
And-
the expressly is not stated as you've keenly indicated, so provided for. It's provided for underneath section 2407. I'm gonna do a quick search here. There is PUD language that's referenced underneath the ZBA statute in a different section, and I want to say it's 2406, which indicates that an appeal when the ZBA, or when the site plan had to be reviewed and a PUD cannot be taken. Let me check that real fast, and that would be the express reference at that point in time. But again, I've given you, and Mr. Zapp has given you his opinion. I'm not going to change mine. He's not going to change his. He'll just get more zealous. I'll get more zealous. And that's just kind of how it goes.
John?
Are you ready to sit down?
Sure. If you're
Okay,
willing.
I just wanted, before you do sit down, I
Yep.
want you to know that I don't appreciate one lawyer referencing another lawyer, our township attorney, as that he is buffaloing us in any way. I think that was a mistake, and you ought to apologize.
No, so I'm entitled to my opinion.
Well, not just saying somebody's buffaloing.
Right.
I think that's wrong,
So
and I think you made a
I think what
mistake.
you're saying is wrong.
Pardon?
I think what you're saying is wrong. I think he gets to say whatever he wants to say.
correct. So
well,
you're
then-
entitled to your opinion, and I'm entitled to mine. And your position doesn't allow you to usurp over my opinion.
Okay.
And that's what, and ultimately what you're trying to do now. And most weaker opinion people would say, I'll sit down and I apologize. No, I won't. Because that's what happens with attorneys is you guys rely on him heavily. He didn't indicate to you that I already addressed these issues and that there's competing ideas. That's the problem. So hopefully that answered your question.
No, you haven't.
Thank you. But what you have done now, sir, is potentially put in a conflict, and I appreciate that. Thank you.
Yep, you're up.
Recognize me. Someplace in the attorney's opinion that we received, it said something about that he was not addressing whether Mr. Pessoa is an aggrieved person. And there is something in the Michigan common law about, says an appeal to the zoning board of appeals may be taken by an aggrieved person. Is that an important issue, whether Dr. Pessoa is aggrieved?
So it depends on where you fall. So underneath, there are certain statutes and underneath to appeal. And so there's case law on, it's 125-3606. I think it's subsection 4. And so the Supreme Court has indicated that you need to be an aggrieved party in order to appeal. And that is specifically addressed on paragraph or page, I should say. Page 9. So I already addressed it. So it's if I want to appeal to the circuit court from this action. So let's say I disagree with Mr. Zappa and I decide to go to the circuit court. I told you when I first started I have two options. And I think I'm just going to sue the township for what's referred to as an original action because they have taken property from my client without just compensation. So if I want to appeal, I would follow the MCL 125-3606, and that's where you have to be an aggrieved party. And I addressed it in my brief to make sure that you knew that. So it's a three-part requirement. One, Mr. Pessoa has participated in the proceedings. He has participated throughout. Two is that he has a special damage that nobody else has. And we're alleging that his property has been taken. And the third one's escaping me right now, but it's addressed in my brief. So that's the requirement. So they didn't read my brief, evidently, because that was addressed.
Brent, were you referring to the Varnum? Okay.
Yeah,
And maybe he didn't get it.
Yeah, so for clarification.
I did get the Varnum,
Well,
maybe
Varnum
Varnum's
might
the
not
person
gotten
who
mine,
said-
so he didn't know.
Said something not addressing,
So just for clarification, for those that don't know, Longyear is potentially an affected property owner as well, and they provided a written comment just like anybody else that showed up in person or provided written comment. You can provide written comment, you could have called me, or you can show up at a meeting. And that's what the representatives from Longyear decided to put together their own letter.
Point of clarification, though, written comments are typically provided with the agenda.
We just received it.
And written comments can be provided right up until the time of the
Correct,
public
but then they
hearing.
would make a copy and it would be provided so everybody else can read it. It's-
We have copies.
So that everybody hears it. That way, somebody's comment doesn't carry more weight. That's why
Yeah,
it's
it's-
public.
it's dated January 18th.
No, I'm just
The
saying like
Varnum.
the due process requirements. That's why it's a public comment. That's why they're supposed to be provided, is that way nobody's opinion
And-
carries more weight.
And that's one of my concerns, is that we've gotten two sets of lawyers' opinions that you and your client have not seen or been able to respond to.
We haven't gotten to the written comment submittal just yet.
But we've had I've seen this since yesterday afternoon, and apparently it's dated January 18th.
I just got it tonight. Anyone else got anything to say?
So now would be the time to reflect written comments submitted, or if you want to hear the public's comments first, either way.
Pete?
We could probably go to the public comments.
Yeah. Further,
I mean, from the public would like to speak. Stand up, state your name.
Hi, Susan Spalding, 285 Forestville Basin Trail. I don't know if I'm commenting or asking a question. I feel like I'm asking a question more. I'm not an attorney, I'm a layperson. And I wanted, I guess, maybe to ask if we that showed up are going to be able to have a copy of that, or is that just for you?
Yes, ma'am.
And then it sounds like from what I'm understanding and what I'm hearing here tonight, is it really isn't enough information for you to make a decision. It sounds like it's going to be falling into the hands of maybe attorneys or a court system. And so I guess how would we, the public, be involved or stay on top or apprised of what's going on? Thank you.
Thank you. Thank you. Anyone else like to speak?
Question.
Step up.
Hi there, Nate Lowen. I live in 225 Forestville Basin. I had other things to bring up, but it seems a little interesting to me that we aren't allowed to appeal a PUD. I'm kind of curious as to why you wouldn't be able to appeal a PUD, and you guys being the board of appeals, I mean, that's for us as citizens to be able to come to you if we have questions or concerns about decisions that are made. I a little bit, I mean, I guess it's written up there in these bylaws, but at some point we need to use a little bit of common sense and say to ourselves, hey, this is a situation, regardless of what lawyers say, can we as citizens discuss this a little bit? And I'm interested to understand why we would ever say in a document why we wouldn't be able to appeal.
Jason or either one of you can answer.
I'll address that. A planning commission decision can either be appealed to the Circuit Court or to the Zoning Board of Appeals. The Zoning Board of Appeals hears other things also that, like variances. The state legislature makes up those determinations, essentially. And in the instance of PUD issues, it says you can only appeal to the ZBA if your zoning ordinance, in other words, if your township expressly indicates, has a provision allowing that to occur. It's most townships do not. The vast majority of townships do not. I represent 14 townships. I can't think of one that has one that goes directly to the ZBA for that type of an appeal. And I, don't quote me on that. There could be one out there I have that I'm not aware of because it's not been an issue, but that would be a very unusual zoning ordinance to allow that. And that's a decision that the legislature makes. Let me give you another analogy that's kind of not directly on point here, but use variances. Generally, the Zoning Board of Appeals can hear variances and grant variances. That's like if you have to set your building 15 feet from the side, but you've got a big rock there, so you can't meet all of those. The Zoning Board of Appeals can grant that type of a variance. A use variance is one in which gas stations aren't allowed in a residential district, but you can apply to change the zoning ordinance, if you will, or to get a variance. The state legislature has also said the ZBA cannot grant use variances unless your zoning ordinance specifically authorizes that. Marquette Township's ordinance doesn't authorize that, and the gist of that is, and I will get a little far afield here, but just trying to answer your question by analogy, is that really modifies your zoning ordinance if the ZBA can just say, you really can have gas stations in a residential area. That's essentially the legislature's determination that it's sort of frowned upon to have ZBAs hear appeals of PUD decisions, but if you really, really want to do that, you can put a provision in your zoning ordinance that authorizes that. Marquette Township hasn't put a provision in their ordinance that authorizes that, and in fact, they have a provision that says PUD appeals are not to be heard by the ZBA.
I appreciate you addressing that, thank you.
Sure.
I would just, on your just comments there, I would like to say that my understanding is you as
Your
a
name, sir?
lawyer.
Your name?
I'm David Peslaw. 135 Forest Road. My understanding is that you as the lawyer is supposed to be an impartial lawyer for the township to understand what is going on here. And you're acting to me like, in my opinion, you're acting like you're lying as a player. There's also something called right and wrong here. There's right and wrong in America, and we've gotten to a point in America, including in this, that right and wrong isn't being considered. We're talking about a little rule, and to me, the statements indicate that the Zoning Board of Appeals should be able to hear this if they want to hear this. It's not specifically stated, I think you're incorrect in what you say, that they do not. They're allowed to, as you said, have a lot of leeway in what they do. Okay, so I'm just saying, I think you should be telling these people the truth and not telling the people lawyer's opinion, which is, to me, what you're giving them tonight, and that's not right. So, in the statement that we send to you, everything is outlined in detail. It's so well done, it's incredible. Dan did a beautiful job, so if you read it, I have nothing more I can say about this matter, but it's wrong. What's being done is wrong, and it was put through in the wrong way to put, and if you put phase one in, no matter how many homes, you're giving them the right to change all the infrastructure, which is gonna cost money, so how are you gonna deny them part two? So, the rest of the subdivision, so then the road has to be changed, and then you take my property. In history, 20 years ago, you took my property, and you made the worst decision, or you didn't make it, the road commission made the worst decision to put that road like it is. It's awful. That road should have gone straight. And then there would have been a site problem, wouldn't have been such a tight problem. I was here 20 years ago complaining that, and they took my land anyway. So I'm complaining this time that you can't do things out of order and do this to change and plus, it's zone rural residential. Read the statement in his statement, what rural residential means. This has nothing to do with rural residential. This is a city in the township. There's not only my grievances there, there's right and wrong here. And I'm just saying, you've got to get by this. I mean, if you want to hear this, you can hear this. If you don't want to hear this, you can go by Longyear's lawyer, which is, that's what I'm thinking you're acting like. You're not acting like a neutral lawyer, which you're supposed to be. There's Longyear, there's mine. You're supposed to be neutral. That's my opinion.
I'll respond to that. First of all, I am not acting on behalf of Longyear. If Longyear were to come in and propose that they want to put in my last example, a gas station, I would be extremely adverse to Longyear on that posture. I am not a neutral attorney. I represent Marquette Township. Marquette Township is my client. My job, I've been doing this 40 years, is to represent to the best of my ability what the law provides and to keep them in adherence with the law. And again, in case I didn't say this before, not only the Zoning Board of Appeals, but the township as a whole has no inherent ability to zone anything. That right is granted solely by the state legislature. And there are a lot of cases that hold that specifically, both in the Michigan Court of Appeals level and the Michigan Supreme Court. So basically, the legislature determines in a statute called the Zoning Enabling Act what rights and authorities a township has to enact zoning and what rights and authorities it does not have. And, you know, at the risk of being a little redundant, the state legislature is saying that ZBAs can't hear PUD decisions except unless the zoning ordinance says so. So it would be beyond the scope of legal authority of this body to tread there.
Can I make a comment in response to Dr. Pessoa? One thing people keep saying is that this is rural residential. I believe it's scenic residential. On the zoning map, it's dark blue scenic residential.
That's correct.
Correct. Scenic residential has a minimum lot size of 5 acres, which is one of the reasons why a lot of people ended up buying places out there. And I always wonder why we have zoning if every time somebody comes in and throws some money around, we just change the zoning. I was reading other municipal organizations' PUD requirements, and they require that the average square footage per unit across the entire PUD, including the green spaces, be at least the same as what it is normally zoned. So you can pack things in tight, but if you add in all the green space, the average lot size is the same. Ours says something different. It says it has to be at least equivalent to urban residential or something different. I think it's urban residential with only 8,000 square feet. And I think that part of the zoning ordinance may be in violation of state law. So I have lots of questions about this, and it does seem like some people really want this to happen, and they're going to push it through one way or another. And when I read the requirements of the PUD, I kind of wonder if the planning commission read them, because it doesn't even seem close to meeting the qualifications for this kind of a unit.
Brian Kramer, 115 here on Woods Drive, and I think we've heard a lot of comments. I'm going to speak to you tonight. I'm not a lawyer, I'm not an attorney, but the word interpretation comes to mind, and how do we get here? And I will maybe pick up where you just finished. I'm passionate about this issue because when I read the PUD requirements, there is a gaping hole of how this could have ever passed. If you look at it, safety doesn't put an undue harm or process on traffic, right? Traffic is unsafe. If you look at the requirements, and I'll use words that I heard Jason say when he described an initial PUD, he said a PUD allows folks to bend the law, or bend the ordinance. This is shattering the ordinance if you look at that. So what I'm saying, and I'll cut it short, is that if you think about how we got here, what the interpretation of is the PUD, right? It just doesn't fit. And I'm not against development, right? I'll do some quick math. 1,800 square foot homes, 350 a square foot. Why put that much space together? There's something in there about certain percentage has to be green space. Well, a certain percentage of that lot out there that they want to build on, you can't even build on. It's cliffs, right? So yeah, it conveniently fits in there. But what I'm asking you is think about how we got here, the interpretation of what that PUD is. It's not even close to, I think, the original intention. So is it greed? I don't know. I don't think it satisfies the need for housing in this area. But think about how we got here and the why and the right thing to do. I don't think it's the right thing to do until you fix that traffic. Fix the traffic out there first. Decide on that before you let this go through.
Thank you. Anyone else? John?
Sorry, just a general comment for the board to consider. Sorry, Casey Banks, 160 Hidden Springs. I think it's a slippery slope that we need to consider when we start taking people's land for the benefit of a private company. I don't think that's right, and my property might not be being impacted directly as much as Mr. Pesla's, but who knows? Someday down the line, that could happen, and that's not right. And I agree with Mr. Pesla's appeal, and I think the board should consider that. Thank you.
Thank you. John, did you have your hand up?
Yeah. Is it okay to make?
Well, we need to finish up the public comment if there's any additional public comment.
Any public comment? Seeing none, close public comment. John?
How do you want to disseminate the written comment that's been provided? Do you want that read into the record, or do you want to pass out copies? Roger, do you have a?
It's not that long. I mean, it is and it isn't. Go ahead and read it into the record. That has been for prior ZBA hearings, something that has been done in the past.
Does anybody want a copy?
And that means that copies can be distributed as well.
Okay. I guess I'll read it because I've read it a couple times. Mr. Mead?
Figured.
Anything else? You guys tell them a new one. Folks? Yeah, there's a couple more. So this letter is from Barnum, who represents Longyear. It's addressed to the Zoning Board of Appeals, care of myself, and it's RE Notice of Appeal, dated December 7, 2023, the appeal by David Pesla, with final approval, Marquette Township Planning Commission, the Planning Commission from there on out, Phase 1A, Longyear Realty Corporation's Forestville Community Plan Unit Development, the Forestville Community PUD. Dear members of the Zoning Board of Appeals, I'm writing as counsel for Longyear Realty Corporation, i.e. Longyear, in opposition to referenced appeal filed in respect of the Forestville Community Phase 1A PUD. We understand that the Marquette Charter Township Board of Appeals, ZBA, has scheduled a hearing on January 25th to review and/or hear the appeal, and we are submitting this letter to bring the ZBA's attention to numerous reasons that the appeal is procedurally and substantially defective and should be denied in its entirety. Project background, I think we all know what the background is on the project, so I'm gonna, if you don't mind, maybe push through that. The approval background, however, is that the Planning Commission, this is on top of page 2, third paragraph. Approval background, the PUD, or I'm sorry, the Planning Commission granted preliminary approval of Phase 1A of the Forestville Community on June 28, 2023, and the final approval on October 25th, 2023. The record of decision for which is attached without exclusions exhibits with this letter for convenience. In both instances, the approvals were based on the application and site plan submitted to the Planning Commission as revised and developed over the course of more than a year and a half to conscientiously address comments from the township's planning staff and Planning Commission, as well as from various governmental departments from whom review and comment was solicited, including the Marquette County Road Commission. Clarify what has been approved. Phase 1A is of the multi-phase Forestville Community PUD authorizes the development of the first 16 homes. Phase 1 is anticipated to be split into 4 subphases, A, B, C, and D, with 100 total potential homes in Phase 1, being constructed over the course of 3 to 5 years, subject to labor and market conditions and absorption rates. Phase 2 and 3 are scheduled to follow, each with subphases for an overall project that may potentially include as many as 240 homes. However, no more than the first 16 homes may be developed without further submissions and Planning Commission approval to amendments to the Forestville Community PUD. The conditions of the Planning Commission's approval of Phase 1A of the Forestville Community PUD are set forth in the record of decision. Longhair has accepted these conditions by its prior letter responses to the township. As such, the township attorney will incorporate all applicable conditions that were part of the Planning Commission's record of decision into that PUD agreement between Longhair and the township, which will be the legal document that governs the project and binds Longhair to satisfaction of those conditions. Nearly a month and a half after the Planning Commission issued its final approval of the Phase 1A Forestville Community PUD, appellant Pasola submitted an appeal to the township clerk and zoning administrator. As detailed below, the appeal suffers from procedural and substantial defects, including untimeliness and lack of jurisdiction, and ultimately fails to present a real issue in controversy, as the crux of the appeal pertains to hypothetical actions that may or may not come to pass as an indeterminate point in the future by a government entity that is not party to the appeal. Discussion of deficiencies with the appeal. Sub 1. The ZBA lacks jurisdiction to hear this appeal. I think we've covered that. I'll go on to the page 3, second paragraph. Accordingly, whether or not the ZBA is authorized to hear and decide the appeal depends on whether the Marquette Charter Township zoning ordinance, grants such authority. In short, it does not. Section 24 of the ordinance establishes duties and authorities of the ZBA and parallels the Zoning Enabling Act in limiting its authority to to hear and decide only those matters specifically authorized to hear and decide as provided herein, relative to administrative review, interpretation of the zoning ordinance, including zoning maps and granting of variances. Upon reviewing Article 24 and the balance of the zoning ordinance, we find that the zoning ordinance does not authorize review of PUD and PUD site plans. In fact, it prohibits it. In regard, Article 13 of the zoning ordinance, which governs the process and requirements for submission of a PUD application and the PUD of the Planning Commission's preliminary and final review and determination, expressly prohibits ZBA review. Regulatory modifications are not subject to the variance approval by the Zoning Board of Appeals. No part of this PUD process of the approved site plans may be appealed to the Zoning Board of Appeals. And then it says section 13.06B4 of the zoning ordinance. Number 2, even if the ZBA were authorized to hear this appeal, the notice of appeal was not submitted within the required time period and is time barred. Apart from the ZBA's lack of authority to hear this appeal, The appeal is also defective because it was filed beyond the deadline for appeals of the ZBA as set forth in the zoning ordinance. It references section 2407 of the zoning ordinance, requires all appeals concerning interpretation of the ordinance or administration of the zoning ordinance be made in accordance with section 18 of the zoning ordinance, which deals with the approval process for non-PUD site plans. And section 18.13 requires all appeals to be filed with the township clerk within 7 days after the date of the decision of the planning commission. In case of other contested actions over which the ZBA has jurisdiction, section 2407 requires filing a notice of the appeal specifying the grounds thereof with the zoning administrator within 30 days of the contested decision. In this case, the planning commission's decision granted final approval for the Forestville PUD on October 25th. See attached decision record. So, had this been a non-PUD site plan approval subject to the ZBA's review, the appeal would have to have been filed no later than November 1st, 2023. The appeal was filed on December 7th, 2023, so was more than a month later than the 7-day deadline for appealable site plan appeals. Even if we were to consider the appeal to be a non-appealable PUD site plan and other contested action, the appeal would have to have been filed with the zoning administrator within 30 days of the October 25th decisions or no later than November 24th, 2023. So whichever timeline might have applied to the decision been appealable, the filing of December 7th, 2023 was too late and the appeal must be denied as untimely. Number 3, to the extent that the appeal could have been filed with the circuit court, it is also time bar based. Since the ZBA clearly had no authority to hear or decide an appeal respecting any part of the PUD process, and had appellant Pasola wished to appeal the Planning Commission's 10/25/23 decision, assuming he had proper standing and could otherwise satisfy procedural and substantive jurisdiction requirements, he could have considered an appeal to the circuit court. Had he done so, Michigan Rule 7.122, which governs appeals from the zoning ordinance determinations, would have required that the appeal have been filed within 30 days after the certification of the minutes of the Board of Commission from which the appeal is taken, or within 30 days after the Board of Commission issued its decision in writing, whichever deadline comes first. So MCR 7.122 considers 2 dates as potentially triggering the timeline to appeal: the dated minutes that were certified, the date of the decision issued in writing, and in this case, those dates were 11/8/23 and 10/25/23 respectively. But since MCR 7.112 adopts the earlier of these two events as the trigger, the deadline to appeal circuit court was 11/24/23, and the appeal is equally time barred in circuit court. Number 4, even if the appeal were timely and the ZBA or circuit court had jurisdiction, the grievances asserted do not relate to any action taken by the Planning Commission and are not ripe for review before any body, as no governmental entity has commenced or threatened a taking of the appellant's property. The crux of the appeal focuses on appellant Pasola's allegation and speculative assumption that there will be no option other than a government taking of a private land of sale to Longyear at some distant point years in the future to make improvements to the county road that will enable the Forestville Community PUD to expand beyond 100 homes. Since he doesn't wish to sell his land, he claims that a taking is inevitable and should be caused to reverse the Planning Commission's approval for the construction of 16 homes in the initial phase of the project. This perverse argument is reiterated throughout the appeal as part of nearly every false and/or misleading claim. In the few instances that the arguments stray from complaining that is a taking that is a fait accompli, appellant objects to the Planning Commission's allowing Longyear to develop a project on its property in a manner that dovetails with the township's planning goals and alleviates a regional housing crisis, essentially because it threatens to disrupt his enjoyment of his parcel just the way it is. This appeal is transparent and is in its self-interest and fails to actually present a live, real issue in controversy, other than the appellant's second-guessing the planning commission's painstakingly careful and considered judgment. Since the claim taking and the essence of the appeal, we will address the claim as if it had been timely made to a proper authority for review. It is well settled jurisprudence that courts and ZBAs will only hear actual controversies that present issues of real interest. In other words, judicial bodies will not consider speculative, abstract, hypothetical, moot, or unripe issues or contingent questions. They will only consider cases between parties with adverse interests and present a real and substantial controversy admitting of specific relief through a decree of conclusive character as distinguished from the opinion advising what the law would be upon a hypothetical state effect. And that's Aetna Life Insurance versus Hallworth 300. Last page, I promise. In this case, there is very plainly no present controversy or real issue capable of being adjudicated in connection with the appellant's claim of a taking. Longyear has not requested that the township or the Marquette County Road Commission or any other public body within the power of eminent domain threaten or commence a taking of the appellant's land for the benefit of the Forestville community. Neither has the township or the Marquette County Road Commission threatened to commenced any taking of the appellant's lands for the benefit of the Forestville community PUD. So no one has threatened or suggested that they intend or are considering a possible eminent domain taking. Appellant simply fears, without any act, statement, or implication, that the taking was going to occur if and when the Forestville community PUD has developed 100 homes and wishes to develop more. Appellant's personal speculative fears that something no one has threatened might happen at some unknown date in the future, which by best projections will not occur before 2027, do not transform unfounded worries into actual controversy and grievance. Any number of different scenarios might ensue respecting the county road and intersection in question, including among them, number one, Forestville might never be developed beyond 100 homes due to the unexpected market conditions. Number two, Forestville might not be developed beyond 100 homes due to the inability to find another way to alleviate traffic concerns. Number three, an updated traffic study performed at the 100 home mark might indicate that the existing infrastructure can accommodate additional traffic in excess of 100 homes. Number four, Longyear could donate a portion of its property to enable a new right-of-way or facilitate traffic quieting measures. Number five, the configuration and curvature of the existing roads could be modified to lessen traffic concerns. And number six, exploration of other feasible improvements to the intersection could present additional options. The list of possibilities is in no way exhaustive, but should amply demonstrate that the appellant's claim as a taking is fait accompli, is pure subjective speculation and a far cry from a real and present issue and controversy that lends itself to adjudication. Moreover, this speculative appeal is directed at wholly and at the wrong parties. Neither the township, its planning commission, nor Longyear would be the ones with authority to advance taking, since the road at issue the appellant is concerned might be widened or owned by the Marquette County and maintained by the Marquette County Road Commission. As a result, if the appeal actually presented a live controversy regarding the taking, it remains filed in the wrong forum and directed at the wrong parties. For the reasons above, the appeal should be denied and dismissed in its entirety. Very truly yours, Varnum, David T. Calder. No additional written commentary has been provided. So number five, persons wishing to comment on the request to recognize, we've done that. Next is number six, the chairperson, if there's no additional rebuttal, can close the public hearing and return to the regular special meeting.
No other,
While that is accurate, that deviates slightly from what I explained to the public at the outset. I had indicated that the ZBA should inquire whether Longyear has anything additional they wish to present at this time, or wishes to rest on the written comment that was submitted whenever it was submitted. So that would be appropriate. And then after that, it would also be equally appropriate or inquire whether Mr. Mead has anything additional that he would like to, input.
do you have any comments?
Alyssa Arwood, Longyear. Nothing further besides what was stated in the letter provided. Thank you.
Thank you.
It's typically more efficient. Clearly, they were provided my brief, but I didn't have the opportunity to have their brief beforehand. The twisting that occurs in this is pretty, outstanding. So last point first. So regarding the taking aspect, that is a live controversy. In the sense that the Planning Commission indicated they have to follow the October, I think it's 28, 2023, letter from Marquette County Road Commission. So those are requirements. So in that October letter, the Marquette County Road Commission indicated in paragraph 2 and 3, which wasn't addressed by the Planning Commission, indicated that the road couldn't handle any increased traffic. So not only does Longyear have to abide by, and to address Mr. Zappa earlier where the 100 units coming from, clearly Varnum is getting the same thing I am, that there's going to be 100 units that can go into this. So let's presume there's 2 vehicles per unit. That's 200, maybe there's 300. So again, we have a circumstance that now they're saying they have presented as a final PUD to the Planning Commission that we're going to put in 240. Now you hear in written brief that, oh, we might not do that. That should be concerning to the Planning Commission when they were basically sought to say we're going to put in 240 units. And then they're saying in written form, well, we may not do that. So there is a live controversy. So it's, you don't have the ability to say you're going to put in 240 and then say we're only going to do 100 at that point in time. One might consider that fraud. The aspect regarding the express language that's underneath 13.6, how you're supposed to read pursuant to how we're taught is basically you have to read everything in context. So section 13 has to be read in its entirety. So what Varnum has done on page, what is it, 2, 3, where they say no part of this PUD process of the approved site plans may be appealed. So you have to read that in context. That's the same thing Mr. Zappa's trying to do with you right now. So that in context is all about what the heading underneath that's Planning Commission's review of the final PUD. And the paragraph in total, so as there are requirements for PUDs, there are site plans and variances that are automatically usurped inside of a PUD. And what that's basically saying is that the individual members don't have the right to basically appeal that decision, but they can seek the variances later thereafter. It does not and is not referenced inside the ZBA where it would need to be referenced. So yeah, so could I sit here and pick this apart and bore you to death on legal procedure and where they're absolutely incorrect? Absolutely. I wish I could have done that beforehand and I wouldn't have been able to bore you, and I just would have done it in writing and it would have been much more well done. Short of that, that would be the, just an example of each rebuttal that can be done on my side of like where the problems are that exist within their argument. Again, the appeal is timely. Again, they don't address in this argument 1306 that says that the preliminary requirement or the final requirement is to follow the preliminary process. The preliminary process is under 1305 that indicates that Longyear has to submit, like they did in October of 2023, I promise to follow the final plan. They have not done that, therefore have not triggered the requirement for timeliness. So the list can go on and on. You know, whether it's going to be an original action or not, I guess the circuit court will have to determine that. So I hope that you agree with me that you have the right to deal with this. I think it's pretty clear that there are gaping gaps in what Varnum believes to be thoughtful process. It just wasn't. The traffic is going to be an issue. Everybody knows that's been an issue. It's going to continue to be an issue. It's not going to go away. It's only going to get worse. So unless anyone has any questions of me.
Ever so briefly, since everybody's been here a long time already.
Thank you.
Is, first of all, the test on timeliness was this filed within 30 days of the contested decision? That is the test in your zoning ordinance. That's what it says. The contested decision was on October 25, 2023. The appeal was not filed within 30 days of the contested decision. Also, in terms of what was that long written comment that you just listened to, that was public comment in the form of writing. So that is just as if the Longyear attorney appeared in person and made that argument. That's what that is. That's input from them, so that's part of the record, but that's their public comment. My conclusion is that the ZBA does not need to, and indeed should not, get to the issues raised in subsections 3 or 4 of that written comment, because to do so gets you to the merits of the appeal, the arguments of the appeal, and that's what I've repeatedly indicated you should not be doing, because A, you don't have jurisdiction to do it, and B, it's not timely. That's, I could say a lot more. There is no taking pending at this point, either in the form of condemnation or inverse condemnation. 16 units are being proposed. The road commission indicated in everything that you've seen that up to 100 would be plausible without, but again, even that is beyond the scope of what you should be examining here tonight, because that gets into the merits of the appeal, which there are other venues for that. So.
Thank you, Roger. Board members discussion?
So are there any other public comments? And if not, then you can close the public hearing. And Mr.
Hold it, we got one. Not to hurry, we're not gonna close before you.
Yeah, hi, Ann Jackson, 230 Huron Woods. I've not come to these meetings because I was working every time, and all the lingo and attorney jargon. I got as much as I could. The appeal thing, from what I understand, is they can appeal because Longyear is not doing the proposed plan that they were going to, correct? And I want to say one thing. I went for a walk. I walked down by that road all the time, down Forceville Road, by the gate. There are stakes all over. There's way more than 16 lots staked out. And I want to get back to what's right and what's wrong. I've lived up in Huron Woods for over 20 years. And I don't know how many times I've almost gotten smooked or my kids at that intersection. Dr. Wiggins that lives up there, her son was almost killed. There were 2 people killed there not too long ago. You've got to take in consideration the traffic survey. Sorry, I'm really nervous. I don't like talking in front of people. So, I mean, that's like one of the number one thing that you have to take into consideration. So, and as far as 16 lots, once they do that, they're going to go to the next. So, I'm not against, modernization and building. I really am not. But the zoning ordinances are also way off. So I don't understand why this, I just don't understand how this all happened, The zoning, the acreage is off, the traffic is ridiculous. 16 units? I don't think so. So all I'm asking is, people need to be ethical and do what's right, not what's wrong. So I'm sorry, I'm really upset. I'm listening to all of this, and it's not right. If you look on the map of the Longyear plan, you will see how much of his land is on that map. And can you honestly say they're not going to use any of his land to work on bettering the traffic? I don't think it's right. So I'm sorry, I had to vent.
Thank you.
Thank
Thank
you.
you for coming up here. Yes.
Dan Mead and I discussed this 30-day thing, and way before the 30 days was up, and the Longyear had not responded that they agreed to the statement. So we thought we have 30 days from the time Longyear agreed to the conditions you put on the thing. That's why the 30 days we got has not even started yet from this. I don't think they have responded, I know of, that they've agreed to those things. So that is why the 30 days was not met, because we didn't think we had the 30 days still started. So that is the response I have to that. Do you agree, Dan, with that?
Yeah, I mean, we checked with the township. We emailed Mr. McCarthy ad nauseam, waiting for the condition. So we have, again, I foresaw what needed to be done, and that's why I emailed Mr. McCarthy many times. Have they accepted their conditions yet? Have they accepted their conditions yet?
One at a time, will you step up there and talk?
Can it not record from here, or?
I don't know. Will it record from there?
I think he's got a voice that's,
All right.
he's a former Marine, so.
Okay.
So we've preserved that issue. So, and again, Mr. Zappa's entitled to his opinion, I'm entitled to mine, and ultimately, somebody will have to make a decision.
I would just like to clear up the existence of this letter. On September 6th, we wrote a letter that was included in the October 25th Planning Commission packet, so the day that meeting happened, and we accepted 4 conditions that were in that packet. So text is small, but I'll read. Approval conditions as stated in the Marquette Township Planning Commission regular meeting minutes from June 28th, 2023. Per the Marquette County Road Commission's recommendation, no more than 100 dwelling units shall be constructed prior to a significant improvement to the Forestville, Commerce Drive, County Road 492 intersection and/or an alternative ingress and egress into the PUD development is created. By way of this letter, Longyear Realty Corporation accepts this condition and will work in partnership with the Marquette County Road Commission and Marquette Charter Township to identify the appropriate funding source to make safety improvements to the intersection. Number 2, all conditions listed in the Marquette County Road Commission from the review letter dated April 26, 2023 shall be met. By way of this letter, Longyear Realty Corporation accepts this condition. All final PUD applications must be submitted to the Planning Commission or Planning and Zoning Department within 12 months of the final Planning Commission's approval of the preliminary PUD plan. Commission met. 4, as this is a public hearing, the developer shall comply with any additional conditions that the Planning Commission deems necessary after hearing comments from the property owners located within the required notification area. Although comments were put forth by individual commissioners, there were no other conditions of approval presented and agreed upon by the Planning Commission. And that has not changed. Those are the conditions that we met. They will be reiterated in our development agreement. Additionally, we have staked clearing limits for the project. It is 16 lots. You just see a lot more stakes in that because they create a continuous line down the project.
Yeah, and for Mr. Mead's edification, that information was sent to you.
September comes before October. October's planning commission indicates 4 requirements. That requires a new letter. You don't get to rely on a calendar system that comes before you actually were approved.
Okay,
So that's where we're at.
understood.
My opinion, their opinion.
Yeah. So that letter was actually submitted as part of your final PUD application in the narrative.
But it doesn't, that was submitted before you made the determination. That's my whole point. You don't get to rely on, oh, that should cover that.
Understood.
Sorry, I'm just gonna scratch my head for a second. So the decision record in that packet, and I think what you're referencing is a response to this. The response is for a letter from the Marquette County Road Commission dated October 18th, which was different than the original Marquette County Road Commission. So like these technicalities are like crazy. I don't know why we would even think that a September letter for a pre-decision we could accept. And I struggle a little bit.
Yeah, I
on
agree
some
with
of this.
you.
Sorry,
Yeah,
I
it's your
struggle,
turn.
right? I sit here and I listen and I see Varnum has a copy of his brief, yet he never got a copy. Like, so where's the fairness here? Like, I'm struggling. Like, where's the consistency and the fairness is what we're looking for. Like, October.
September, yeah. September, October.
I have one question too. Susan Spalding, 285 Forestville Basin Trail. I remember being at one of our previous meetings, and I remember that there was a comment made that if if Marquette County Road Commission didn't better the intersection at Wright Street and Forestville, that Marquette or Longyear would be under no obligation to improve the road. And that was, I guess, clarified or agreed upon at that meeting. So I just wondered about that. Thank you.
And I can respond to that briefly also. I was at that meeting as well, and it was made clear that the township would also be under no obligation to make further improvements or approvals of additional units or additional phases. And PUDs are frequently made in phases or approved in phases. Only phase 1A, which is 16 units, is what's been approved here. So if, for example, down the road, pun intended, things don't look well on the safety of the intersection, then that's a whole new application process for Longyear. That's something completely different that hasn't happened yet even. So the township is not committing to 100 units or 240 units. They're committing to approval of 16 units. And again, that's way beyond the scope of this ZBA hearing to some degree, but I just I wanted to help clarify any misconceptions there might be on that issue.
And the timeliness issue is ancillary to what the zoning ordinance says. That we're splitting hairs. Any more public, you gotta give the public.
Any more public comment?
I think we all understand each other's sentiments and arguments and opinions, which is beneficial.
All right, seeing none, close the public hearing at 7:10. And we'll have the board. John?
2 points that I'd like to make, and then I'd like to have the role of a chair point, making a motion. First point I'd like to make is that the Forestville Road, Wright Street intersection traffic has been a nightmare and a threat for a long time. We all know it, we've worked on it, but ultimately, it may not involve adjacent property. We don't know how that's going to work out. The second point I'd like to make is that the appeal is centered on action taken by the Planning Commission. And more properly, if you got a complaint, personally, I think it belongs there. But to get on moving, the township has to move. We have to take a look at this. So from the ZBA, we traditionally put in any motion that's made our findings so that it's easy to see where we were coming from if the motion passes. I'd like to make a motion to adopt the following findings and determinations, and I'll share them with you in writing if it's supported. The Zoning Board of Appeals findings and determinations, I have 12 of them. That's a lot. And I know that. And I don't expect anybody to be taking notes in detail of those 12. So I will cover that at the end of, if there's support. Number one, the Zoning Board of Appeals authority to hear and to decide appeals is controlled by the Zoning Enabling Act, and the Marquette Township zoning ordinance. I think you agree to that. This appeal involves a planned unit development, final proven decision made by the Planning Commission. At its October 25th, 2023 meeting for the Phase 1A of a project presented by Longyear Realty Corporation. A recording of that meeting is posted in its entirety on the record for anyone to see. Third item, Section 6031 of the Zoning Enabling Act, MCL 125-363, provides for in relevant part for special land use and planning unit development decisions. An appeal may be taken to the Zoning Board of Appeals only if provided for in the zoning ordinance. My fourth point, Section 1306B of the Marquette Township zoning ordinance addresses Planning Commission final approval of a planned unit development plan, PUD, subject 4 of the same section. Specifically notes, no part of this PUD process of approval may be appealed to the ZBA. That's in our ordinance. There's no provision within the Marquette Township zoning ordinance authorizing the ZBA Board of Appeals to hear PUD appeals as required under MCL 125-363. The Zoning Board of Appeals has acquired jurisdiction in PUD matters only if it's in the record. Therefore, the Zoning Board of Appeals finds that it has no jurisdiction or authority to hear or decide an appeal from this page or to grant relief requested by the party. Additionally, even if the Zoning Board of Appeals determination that it had jurisdiction to hear a PUD appeal, the Marquette Township ordinance requires that the appeals to the ZBA of Appeals be filed with the zoning board 30 days, within 30 days of the contested decision. Item 8, the final approval of the PUD being appealed in this case was made by the Planning Commission on October 25th, 23. 9. 30 days from the date of the Planning Commission contest we're hearing would fall on November 24th. That's being contested, but that's what it says. The appeal of this matter is dated December 7th, 2023, and was not filed with the zoning administrator on or before November 24th. The Zoning Board of Appeals further finds that even if it possessed jurisdiction and authority to hear or decide this appeal involving a PUD approval, the appeal was not timely under Marquette Township zoning ordinance. In light of the above findings, the ZBA does not reach or address other potential arguments, issues, including whether the party filing the appeal is an aggrieved party or has standing to appeal the Planning Commission decision. That's a long motion, and if there is a support for that, and if there is a vote on it that approves it with a roll call vote, I would ask for, then I will pass out those comments in detail. Is there support?
Is there support?
Well, I'd like to make a couple of comments. I'm extremely empathetic to Mr. Pizzola's.
Bobby, have a support before we have
Pardon me?
discussion?
It needs to be supported before we discuss it. If there's no second, it dies for lack of a second. And it cannot be
Okay.
discussed unless it's
I
been
mean, I'll
seconded.
second it.
Okay, good.
Fine.
Okay. For the purpose of discussion, he's going to second it.
I'm extremely empathetic to this situation that you're facing, and I would hate like hell to have some sort of development come by my very nice property. So I understand that. I really feel, having spent 30 years in the military, that regulations have been imposed on me when I don't agree with them. But in this situation, I have to agree with Mr. Zappa that it seems we don't have the authority to make a ruling on this. So my vote is to support the idea that we don't have jurisdiction.
Any other comments from the board?
Is it,
I support it.
I think Brent has some comments.
Yeah, good, go ahead.
So, John, did you write that?
I had help.
Did you write any of that?
I
Did
wrote
you
some
write-
of it. Yes,
you
I
wrote
did.
some of that?
Yeah.
Okay, well, it's word for word what was given to me by Mr. Zappa.
Yeah, he appreciates my help.
You're serious?
I'm sure he does.
You're serious that you wrote
I
parts
didn't
of
say
this?
I wrote it. I said I had help with it. And so that help has come from all sources available in the administration, including the attorney.
Okay, so, we got a packet, and normally you read a packet from front to back. The first thing in the packet explains to me what I'm supposed to think. And the second part tells me what I'm supposed to say, with a pre-made line for me to sign. After that, I get to see the appeal and those arguments. We keep hearing, it's only 16 units, it's only 16 units. I think my little brother used to use that ploy on me when I was a little kid. Oh, it's just a little bit, it's just a little bit. Oh, we don't have to deal with it because it's just a little bit. This is not a plan for 16 units. This is a plan for 240 units. So why do we keep throwing around this misnomer that it's a plan for 16 units when it's not? I have one question. Is approval of a site plan seems like a map that says things. Is approval of a site plan synonymous with approval of a planned unit development? Okay, if it's not, then there are two things that keep being brought up here. This statement in the zoning ordinance that says no part of this PUD process of the approval of approved site plans may be appealed to the zoning board of appeals. One, grammatically, that doesn't even make sense. Okay. Two, it refers to the process of site plan approval. Okay. It doesn't refer to the approval itself. It says you're appealing the process. You're saying the process wasn't carried out. So I think that approval of the planned unit development may be a different thing, and there are all kinds of things in there that the qualifying conditions were not met. And so I just don't understand how this was approved in the first place. The second, I think that we do have jurisdiction to take a look at this. If we don't, what are they going to do? Throw me in jail? I don't know. I'll find out. But the second one with timeliness, I think that one is absolutely clear that no deadline has been missed. That's just absolutely clear in black and white. And so, just because a lawyer says something doesn't mean it's true. I think we can probably agree on that because I think you can find a lawyer who will say just about anything you want them to say.
Oh.
Well, I've read the news enough times that that there are people saying exactly contradictory things and they can't all be right. And so for us to just be handed something and say, well, I'm a lawyer, this is what's right and this is what you should think and this is what you should say, I'm uncomfortable with it. I personally would like to see a lot more information. I would like to see written rebuttal to the statements that we were provided before the meeting even. These were not provided as public comment at the meeting. These were provided to us ahead of time. They were probably solicited. I don't think the Longyear lawyer just happened to find out about this. I would also like to see the road commission report that I've never seen. I'd like to have more information. And you can't make a motion while a motion is on the table. But I would like to see this thing postponed until more information is available. And barring that, I would vote against the motion that's on the table, and I would like to then consider the appeal.
Pete?
John?
Roll call vote.
You should ask if there are any other comments.
Any other comments? Seeing none, we'll have roll call. Bill?
Yes.
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 No.
No.
Motion passes 3-2.
So disgusted.
Yeah, me too.
Thank you.
Okay, old business. Correspondence reports.
The additional thing.
Any announcements?
Yeah, 3-2.
Public comment? Apparently not. Come on up.
Yes, Susan Spalding again, 285 Forestville Basin Trail. I know you're here to represent us. We are all people in this community. We're the ones that are coming here that are willing to get involved, want to be involved. And I agree with you two gentlemen, we don't have enough information for, in my opinion, the three of you to make this vote. I remember being at a previous meeting and there was two that wanted to not approve this, 3 that did decide to approve it. And one of the arguments at that point in time was, I grew up on a postage size lot and I turned out just fine. I am not an attorney. I'm just a regular woman that has, I guess, the interest in doing what's right for our community. And I just feel that decisions can't be made lightly. We have to have the information to make the best decision, not just go by a gut or just what's popular or just what's popular for the economy. We have an economy that definitely does need to have consideration, but there's so much more that is involved in this. And I'm just really sad with the final outcome today, and I really wish that you three, as much as you seem to be wonderful gentlemen, would have taken their consideration or their viewpoint into play here, because there is not enough information that has been presented tonight, I feel, to have the supporting a vote for the 16 or the 100 or the 240 to proceed. Thank you for listening to me. Have a good evening.
Can I make one comment in response?
Yes.
I was at the planning commission where this was approved, and I remember one of the commissioners saying, well, I drove up Forestville last weekend and I didn't think the traffic was bad. That's sort of like your postage stamp sized lot comment.
Thank you.
I have one more thing I'd like to say, Jim. You guys just voted that the Board of Appeals will not appreciate appeals. To me, that's incredible, based on what your lawyer said. I want you to think about what that means to us as people, as citizens, that if we were to try to appeal something, we can't even go to the Board of Appeals. So, thank you.
Any more? No?
Against my lawyer's advice, I would say that to approve a motion that is made before the meeting, before all the comments are made, and then just read that off and approve it, to me, is wrong. That's all I have to say. It violates due process of the meeting. So that's, I don't know what Mr. Zappa says about that, but you're the one that made it.
You didn't write that.
Ann Jackson, 230 Ironwoods Drive. I was about to come up. I totally agree with Dr. Pesala. What you did was unethical. You had it all done beforehand. So me feeling, or these guys, that you've listened to us, I don't think so. We live on that road. We drive it every single day. Every time my kids, they're 28 and 26 now, every time they drive, I'm nervous. Every time when they go out from, Forestville to Wright Street, I'm nervous. Every mother in that neighborhood who has a kid who drives is nervous. And I'd like to know, did you guys walk the land down there? Have you seen the water that's down there? It slopes down. There's lots. Okay, I'm gonna quit. I'm sorry.
In response,
Yeah.
remember John Berry? I
Yes.
drove him to the hospital when he got creamed out there.
Yeah. I think if you guys drive it every day, down Forestville out to Wright Street, you'll see how dangerous it is. I'm disappointed.
They just don't represent us.
No, not at all.
Additional comments that ZBA members want to make? No more public comment, so we're up for adjournment.
I move we adjourn.
All right, second? Second. All in favor, say aye. Aye. Opposed, the same. Adjourned at 7:30.